Thank you, Peter. Dear audience, it's the last lecture of a long day, so I want to make it as short as possible, but I want to start with some preliminary remarks. First, I think we have to conceptualize the topic and the importance of privacy in a social cultural environment. So this is somehow deeply enshrinked in nations' individual history and, as I said, in a social cultural background. I mean, you can easily say that if you look at Scandinavian countries where you have even public lists of tax payments, which for a German is really an awkward idea, but apparently Scandinavians do not have problems with this. On the other hand, we talked the whole morning and the whole day about common standards, about international cooperation, about coordination by the OECD, and about EU harmonization. So, I mean, somehow there is some tension between, on the one hand, a very national concept of privacy, and on the other hand, this attempt to come to a common standard. And then I think we have to be very aware of, if the European Union takes over and harmonizes, that also has some influence on the competence of national constitutional courts. So if we will in future times check whether the EU laws will be in line with our understanding of privacy, probably this will go immediately to European courts and not stay longer with the German Constitutional Court. And therefore we have to look very carefully what are the differences between the European court practice and the German court practice. Even so, maybe this is really also talking a little bit about the past, if it will be all brought up to the European courts. So, saying that as in comment, Germany has a very strong notion of privacy. So also the German Constitutional Court established very strong rights of, well, in our topic of taxpayers to protect the privacy, and that just, I mean, to give you an idea of the general notion in Germany. So what do I want to do? As Funda already mentioned, and also my Turkish colleague just said, looking at tax transparency is somehow has two directions. There's, on the one hand, the transparent taxpayer, and the most of the European law, what's going on there, is about the transparent taxpayer and about exchange of information, and not so much about transparency of tax administration. And also from a constitutional point of view, there is quite a discrepancy between these two directions, because, I mean, if we talk about the transparent taxpayer, then it's about constitutional restrictions, protection of the taxpayer. If we talk about transparency of tax administration, then we have to construct rights and guarantees of the taxpayer to get something from tax administration, which is much more difficult than protection from the tax authorities. So, and I will try to give you an idea of these two directions, on the one hand from a constitutional point of view, and on the other hand also from a sub-constitutional point of view. I mean, this is really well, sometimes I will just have to mention some laws and will not be able to talk about them really in detail. So, one word again to the two directions. As I said already, also from a constitutional point of view, there are some overlaps, but also we have to look at the differences. So if we look at the transparent taxpayer and his protection, then we will talk about the right to informational self-determination, maybe also to entrepreneurial freedom, and the rule of law. The proportionality principle also plays a major role. If we talk about the transparent tax authority, it is already kind of difficult to find really legal sources to construct here rights. So probably it's also the rule of law. It might also be somehow the right to informational self-determination, because I need to have information about what the tax administration knows about me, so I can really also fight on the grounds of the right of informational self-determination against the tax authority. So there is some overlap. Okay, starting with the first point, the transparency of taxpayer and the constitutional constraints. So first of all, as I already mentioned, the German Constitutional Court in 1983 was a landmark decision. Population census is very strong in this field by establishing a right of informational self-determination. Even so, we have no explicit rule in our German constitution on that. So the ground is a guarantee of human dignity and the general freedom of action. This right of informational self-determination since then, since the early 80s, really became a very prosperous foundation of all these issues. So it has a very broad scope, and that might be different also, is different to what Victoria Wöhrer told us about the European discussion. It also applies to juridical persons. So it's not restricted to natural persons, it also applies to juridical persons. And then it goes from collecting, storaging, transferring, linking to data. So it really covers the whole process of data use by public authorities. Of course, this is not an absolute right, so it can be also restricted, and these restrictions can be justified. I will come to that in a minute. It's actually the standard what we apply for justification of limitations of constitutional rights. They all have to meet the proportionality test, so that means that we always need a legitimate goal for this restriction, and then the measure has to be appropriate. It does not go beyond what is necessary to achieve the goal, and it has to be reasonable. So what does that mean now for taxation? I mean, this decision, the population census decision, was not a tax case. So what does it mean for taxation? Well, first of all, the obligation of the taxpayer to cooperate with the tax authorities results, of course, in extensive reporting requirements which always interfere with his or her right of informational self-determination. On the other hand, the information reported to the tax authorities, I mentioned it already, is fully covered by the guarantee of the informational self-determination. So not only private or personal information, but also business information is covered by this constitutional guarantee. However, of course, there's a very important, very legitimate public goal for this collection of information. This is the equal tax enforcement. And this is actually always a problem. We have to balance this. On the one hand, the strong right of informational self-determination, and on the other hand, a very strong essential goal of the tax authorities, because otherwise it's not possible to enforce the tax law equally. So what does that mean in detail? Well, and lots of it will sound familiar to you because we talked about it already from a European point of view, from a Turkish point of view, and I mean this is also somehow relaxing that we see, even so I said it has to do with cultural and history environment, we also have a very common understanding also. So first of all, we always need an explicit legal base if we want to collect data, if we want to use it, to store it, to transfer it. There was, for example, one very, I think not critically discussed, but discussed case in 2015 by the Fiscal Court of Cologne, and it was dealing with the question whether tax authorities more or less informally could exchange taxpayers' data well, just to get an idea of BEPS phenomena. So it was not even individualized, but it was just to see what kind of models of tax planning is out there, and just to inform other tax authorities. And then the Fiscal Code of Cologne said, no, well, we need for this, we need also an explicit legal base. We cannot do that without it. Even so, it is of course an important goal to tackle BEPS constructions. So then also Funda mentioned that already, there's a strong right that no hidden data collection is permitted. So that means that normally the taxpayer has to be notified about data the tax authorities receive from third parties, data which are transferred, for example, to foreign tax authorities. So notification is a very important aspect also of this right of informational self-determination. Then also data may not be retained, there's no data retention without a specific purpose. So it's always important, also Victoria mentioned that, it's always important that you have to make a relationship between the purpose you collect the data for, you store it for, and also the way you deal with the data. And then I think also quite interesting, we have a Constitutional Court decision which was also dealing with the rather technical aspects, and there it was said that we need confidentiality and integrity of IT systems, because this of course is also something we maybe also as jurists we have a hard time to talk about. We don't know so much about all those technical issues, but at least the Constitutional Court said, well, this has to be guaranteed that this is integer. So you see already it becomes, if you look at different court decisions, it becomes more and more precise, more and more concrete. One thing is very important, I think it was also already mentioned, we do not need any objective, or we have an, let's put it that way, we have an objective liability of the government for any violation of the right to informational self-determination. So that means that we do not need any other material or immaterial damage. So just, I mean, the infringement of the informational determination as such is enough. So if we consider, if we recall that this right of self-determination is so broad, then you also see that in Germany it is sometimes discussed, besides that, the freedom of profession and property is not so important. So of course you could also, from this fundamental freedoms, you could also come to data protection rights, but actually it is not really discussed, and therefore I wonder whether public country-by-country reporting, I mean, so far we have no court decision on that. We have not even a very active constitutional debate on the public country-by-country reporting. I mean, of course, you could say it could violate the freedom of profession, but probably it would be also something which we would deal with in the scope of informational self-determination, and then we would just ask whether it is appropriate and if it's necessary to make this information public. So maybe one word, I haven't covered it by my slides, to the rule of law, which of course also is a restriction to tax transparency. And I mean, we discussed already this morning, the rule of law especially would be considered to be relevant in cases where we have this illegally provided information. We talked already about the acquired CDs with tax data, with stolen tax data, and I mentioned already that the Constitutional Court in Germany was quite liberal on this. So, coming to the sub-constitutional level, it's quite difficult because we have, of course, many single little rules on that. I want basically to say some words on the German tax secrecy and also on, well, the bank secret, which is actually not existing, but some people still think that Germany has a bank secret. I will talk about that also. So the tax secrecy, which is laid down in section 30 of the General Tax Code in Germany, well, it has a sort of a broad scope. It addresses to any public official, and basically it also covers all information gained in the administrative process, in the auditing process, or also in criminal proceedings. I think this is actually not so important. More important and more interesting are the exemptions. So when is it possible to transfer data which was collected in the tax administration process to other public authorities? There we see a quite extensive catalogue of exemptions from the tax secrecy. So, I mean, I don't want to go through all these points, but you see already that there is an exemption, a general exemption in this section 30, if it is expressively allowed by law. And we see more and more of this special exemptions for tackling of social welfare abuse, money laundering, for tackling of terrorism. So all of these very important public goals which allow exemptions from the tax secrecy. But I think this is actually also what people maybe worry most about, whether information given to the tax authorities will then be fully available, fully transparent to all, and really to all public bodies, because that makes it not only a transparent taxpayer, I mean this is necessary to collect the tax, but this makes taxpayers totally transparent to the whole government. I want to skip the exemption for the international exchange of information. We have a special provision on that, or several provisions in the German General Tax Code, because we want to talk about it tomorrow also. But of course, this is one of the most important exemptions, which somehow also allowed to cross the borders of territoriality of tax administration, and actually without this we cannot talk about all we did today about the exchange of information. Bank secret, and I think you raised the issue. I mean, are these secrets we were used to, like bank secrets in Luxembourg, in Switzerland, are there somehow a competitive advantage or disadvantage? Is transparency an advantage or a disadvantage? I always thought that Germany was not very smart, because I mean, if you read the General Tax Code, you find the section 30A, and then it has an odd title, confidential relationship between credit institutions and their customers, and it was sometimes said this is a German bank secret. By now, countries are blamed for having a bank secret, and we still have it in our code, even so we have a proposal to abolish it. We still have it in there, but it is not a bank secret. It never was. It actually, well, it limits only the scope of investigation in audit of a bank. So if the bank is audited, which is of course permanently is, then the tax authorities are not allowed to systematically also investigate the bank client's tax circumstances. So this was all. So always, if there was a request for information to German banks, the German banks had to answer on the specific requests. So it is somehow misleading. It is also, actually, it lost its relevance basically after Germany introduced a final withholding tax on interest payments. So it really, it has to be abolished, and I hope it will so. So I don't want to go through all these special provisions. I could have made an even longer list. They all show what I basically already told you, that we have, if we go from this general, very general, fundamental constitutional guarantee of the right to privacy, if we go down, then we see basically notification requirements, then also we see restrictions for the electronic data storage and so on. So we have lots of these provisions in the German code. An interesting question, and that is also a bridge to the European development, is whether besides all this specific text data protection laws, we can also rely on the general data protection laws, because these general data protection laws will probably first be adopted to the European Data Protection Directive and Regulation. Well, it's not so clear. The German Constitutional Court said, well, yes, it is possible if we have no rule in the tax laws, then we can rely subsidiarily on the general data protection laws. The Federal Tax Court was somehow reluctant and said, well, I mean, it can be also on purpose a non-regulation in the general tax code, so then this would be blocked. So if we say, well, if the general tax code does not give some rights to the taxpayer, then we are not able to fall back on the general data protection laws. This is, in my view, a still open question. So quickly to the second direction of tax transparency, the transparency of tax authorities. As I said already, it is much more difficult to find already a basis for that, and probably mainly we have to rely on the rule of law. The rule of law, of course, contains a guarantee of publicity, which we have, of course, for any parliamentarian legislative act, because this needs to be published to come into force, but it's less clear for circulars for directives from the administration. Then also transparency of the tax authorities and how the tax authorities will deal with the case is important also for the equal tax enforcement. I will come to that back in a minute. Maybe sometimes it's even hindering equal tax enforcement if the taxpayer knows too much about how the tax administration will deal with his case. But at least for the taxpayer, legal certainty and equal access to the law is also how the tax administration works. We heard that already, fairness of administrative procedures is also to mention here, and then we have no constitutional right to be heard in administrative proceedings. We have that, of course, in court proceedings, but this I consider also as part of fairness of administrative procedures, that you have the right to be heard also in front of a tax administration. As I said already, also the right of informational self-determination contains the access to personal data, because if I don't know what data the tax authorities have on my case, then I can also not protect myself against its use. What is the practice of publication by the German tax authorities? Well, administrative regulations are generally published. Even so, there is no legal obligation. It's just established by case law. But if it is not published, I think it would be very difficult really to get protection by a court that this has to be published. I just raised that already a little bit. We have a new section in the general tax code where it's dealt with intransparency and wanted and intransparency of the tax administration. As I said already, normally regulations by the administration are published, and there is even a ban of publication in the field of risk management procedure. So we have now an automatic risk management procedure established in Section 88, and then it says, and how we do it, we will not publish, and it's forbidden to be published, of course, not to give the taxpayer the chance to move around this risk management procedures. What we also do not have, and this is something I think it's really worthwhile to be discussed, is the publication of tax rulings. And this, I think, is also, again, a question of equality of taxation and of the right, well, the equal also rights of competitors, because if we do not know what tax rulings my competitor has, then of course I cannot protect against unfair treatment. And we not even have the right to access information in terms of charitable organizations, how they are taxed, even so there would be I think a tremendous public interest to know that, but so there we do not have any obligations of the tax administration to make that open. Just to come to an end, and I touched it also already, there's this question, how can I get access to information if I want to approach the tax authorities? So the only, it's already limited, of course, to the own tax case of the taxpayer, and whenever a taxpayer wants to get information on the treatment of another taxpayer, then of course the third party's right of privacy will be encroached. So, and the tax administration is also very restrictive in dealing with these requests for information, just also saying because of capacity limitations, they are not able really to make the distinction which information is only to the case of the taxpayer, which information might also invoke rights of other taxpayers. So that explains why we do not have a right of the taxpayer to have access to his own tax file. So it is not laid down in the general tax code. I mean, you can ask why should he need that? He gave all the information, but of course, if you think of information from foreign tax authorities, information from third parties on his own tax case, of course, the taxpayer has a right to have full access to his own tax file. But as I said, we have no right to this in our general tax code. And also, it was questioned whether we have some general information access laws, whether they could give this right, but also there we have no court practice so far. So this is really, I think, a blind spot. This transparency of the tax authorities is not very well established in Germany. Thanks.